Orders don't really matter for purposes of immigration, but I still use them.
Welcome back to Visa Vibes. I'm Emily Newman, managing partner at Reddy Newman Brown PC.
And I'm Stephen Brown. I'm a partner at Ready Newman PC as well. And Emily, we're going to talk about something that's getting employers, employees, applicants for visa benefits kind of caught off guard because it's a change in adjudication where we're seeing drastic changes in new RFEs and noise that are kind of unique.
Yeah, we're seeing definite increase in requests for evidence, notice of intent to deny, and they're not about whether the beneficiary qualifies for the job, whether the job is a specialty occupation, whether it's specialized knowledge, or things that are related to the actual visa category. These are what USCIS calls a discretionary analysis.
Okay. Yeah, so they send this, and we'll talk about how these have come about because it's come about really in two different flavors, but it could be more. But it's we don't they don't even go through the merits. It's not like okay, we don't think this is a specialty occupation. It's we're just going to not exercise our discretion to grant you part of this request. And so let's talk about that, Emily. What is discretion?
Yeah, it's crazy. Like you can technically meet every single requirement and qualify, yet they're still going to deny
Yeah.
potentially. So, before we talk about what discretion means, let's talk about like what it applies to because it's not really a rare situation anymore,
No.
not just these edge cases. The most common situation for the last 20 some odd years I've been practicing was nunc pro tunc.
Right.
So if I have to, for some reason, file something late, file an extension late, file a change of status late, and it was due to extraordinary circumstances that were not within my control, USCIS had the discretion to overlook my late filing and approve the extension, approve the change of status, and put me back in status as if I never fell out of status. That was using their positive discretion. Then we started seeing it in some EAD applications. The first time I got an I-765 RFE saying, we've noticed that you might be subject to a ground of inadmissibility, or we've noticed that you have a DUI. We intend to use our discretion to deny your I-765. I was like, they can't do that. And then I looked at the regulation, and yes, they do actually
Right.
have that discretion. I've just never in 20 years seen them use it. Then it expands to advanced parole, I-131. All of a sudden, we would see not even an RFE, just a straight denial saying, we think you might be inadmissible, therefore, we're using our discretion to deny your advanced parole. So that's kind of the four situations in 20 years where we saw discretion. But now,
Yeah, Emily, this is I'm so tired of the word discretion. Okay. I saw it once in a 485 where, I don't know, I think the individual had gone to like 15 different colleges, like got kicked out of some, like some arrested, like, we just aren't going to do this. And I'm like, okay, like fair. Um, but we're seeing it now in very germane cases, changes of status, extensions of status. When we do a case, let's talk about an H-1B. You have two different adjudications. Do you qualify for the benefit and do you qualify for the change or extension of status, the I-94? They can approve the H-1B because you meet the statutory and regulatory, factors and deny the change of status or the extension of status in their view as an act of discretion. We've seen it with EADs, H4 EADs, the C9 EADs. We've seen it with OPTs, FEM OPT, adjustment of status, and we're seeing it not isolated incidents. It's different types of forms, it's different types of benefits within those forms, it's different types of service centers. It's all over the place.
yeah, and it's hitting people who think they have clean cases, students, professionals, people who followed all the years, and suddenly they're getting this notice that feels like it's a character evaluation, even for traffic tickets. Like I literally responded to one today that was due to a traffic citation from 2017.
I, you know, Emily, I laugh because I go back to being in the courtroom when we were doing the Sevis litigation, and one of our criminal aliens, okay, and they kept calling him a criminal, and judge said, like, no, he got arrested. He bought a new car. It was his birthday. He went to a parking lot that was empty and did donuts. And the judge is like, really?
You're gonna call him a criminal
Like,
alien.
this is dumb
These are
college kids being dumb college kids.
these are the criminal aliens, the worst of the worst that I
Right.
claim to
So
be rounding up.
nobody hurt, no property damage, went to an empty parking lot, did donuts, cop hears it, and they called him a criminal. And, you know, he had this same thing. So we see two ways these are really coming up, right?
Yeah. So the first one is that criminal history. So if you have any kind of law enforcement interaction, like not even a conviction,
Yeah.
sometimes not even an arrest, but sometimes, I mean, it's definitely old cases, which doesn't make any sense to me because a lot of these people have already submitted their documents to the consulate at the port of entry, sometimes even to USCIS. Um, and now we're questioning it again. Even dismissed cases, even expunged cases, um, they're now saying, well, even if you qualify for this extension of status or this change of status or this EAD, because you've had this law enforcement interaction, that's a negative discretionary factor that we're going to take into account when we're trying to decide, do you deserve this benefit? And so you have to show that you have enough positive discretionary factors that outweigh this one negative. Otherwise, we're going to deny your application.
Yeah, it's kind of ridiculous. But not as ridiculous as the next one. The second one we're seeing is travel ban related negative discretions, and this came out of a November memo that, to be honest with you, I forgot about. All the drama we've seen where they tell. Joseph Edlow tells USCIS adjudicators to consider negative country factors from travel bans. And so what we're seeing is these 212F bans, which everybody knows is an entry ban. That's how it's written. There are court cases saying you can't even pause visa issuance at the Department of State because of a 212F ban. But they're going to take that as a negative discretionary factor. And we've really seen it with changes of status. I think we'll talk about this more, where they're saying, we're trying to circumvent the travel ban. There are many reasons to file a change of status. It's going to go in for consular processing, convenience, costs, whatever. But we've seen it, and they're starting to use, oh, you're subject to a 212F entry ban. You're trying to skirt that.
So, I mean, most people would think a travel ban applies to someone who's traveling or trying to enter the US. These people are in the US, they're lawfully here in some other status, filing a change of status, or they're filing an extension of status. How in the world can they say a travel ban applies?
I'm just telling you what USCIS is saying because I agree, right? We have these entry bans, and we have case law that says you can't pause visas just because of a travel ban. Now you can prevent entry. That's how it works. It's an entry ban. The president can bar entry. But I've never seen it in the first Trump administration. We had 212F bans then. Everybody, you know, it was treated, you're safe in the US. So it's something we'll talk about here.
Yeah, and so the scary thing is, you know, once USCIS starts using this logic, and if they're able to get away with it in this one travel ban situation where it's this country-specific list that started with 19 countries, then expanded to 35, and now we're up to 70 today. What if it spreads? Like there's other travel bans currently in play. I am sure the Trump administration has a file of new travel bans. They're just waiting to unleash on us if somebody does something they don't like and the media gets a hold of it. Could
Yeah,
this spread to other?
yeah, I think last week on our podcast I said there's a file cabinet. I actually think it's Stephen Miller's nightstand. You know, he's just waiting for the news, and then he goes, you know, in the middle of the night and finds the one. But it could spread. I think we'd have to see changes in policy. But as anybody who's listened in the last year knows, that can happen as soon as we stop recording today. But when you get these notices of intent to deny, these requests for evidence, you know, it'd be real simple to be like, oh, you asked for the court documents, here you go. And, it'd be like done with it. Like, that's what it says it wants, but you've really got to treat this like a character in an assassination trial. And, what are the positive factors? Why should you not even consider what you're considering as a negative factor? And try to push that envelope. But what some of these are weird, um, is they're going to the employer, right? Like, let's talk about an H-1B. We've seen these pop up, they get the biometrics and they say, hey, you have a criminal record. What's up? Send us the paperwork and the positive, we know that we've seen the third RFE, so now we just address it in the second one, right? And so you get employers that are like, you had a DUI? Like, when now the employer has to put together these positive discretion analysis. And I would tell employees, like, work with your employer the best you can because nobody's a better salesman of you than you.
Yeah, and I mean, I've seen companies that say, nope, we're not going to respond to this. We're washing our hands of you. You're fired, you
Yeah.
know?
And I've seen some that are just completely out of context, right? They got I remember a case you and I talked about. It was a tragic accident. The guy got arrested and fingerprinted, and then there were no charges ever brought. And it was truly a tragic accident, but nothing ever happened. There weren't even charges. It wasn't dismissed. There was no prosecution. But because he got fingerprinted, he's now got to talk to his employer about one of the worst days of his life and get them to explain it. And it's just terrible.
Yeah.
So why does discretion matter? What does it really mean?
Yeah. So the Immigration Service early in the Trump administration did kind of reiterate that there are certain benefit requests that USCIS does have discretion on. And that means that they basically have the power to approve or deny, even if you meet those baseline requirements. So there's something in your history, in your background, that makes us think you don't deserve this, even though you meet all of the basic requirements for it, and they can deny for that.
Yeah, and I don't necessarily agree with their full list, right, that they have in their policy memo, but that's the hill we're fighting on. There are some that are statutory, the adjustment status in the Attorney General's discretion. Um, and a little off script here, but I remember being in the Fifth Circuit and, we were talking about discretion in the adjustment of status context, challenging a policy related to it. And Judge Willett with the Fifth Circuit looked at USCIS and said, how far is discretion? Because our argument is there's left and right limits. Like, it has to be a lawful application. And he said, could you deny benefits to people from Africa just because of who they are? Oh, Judge, we'd never do that. Well, could you deny benefits to Catholics? Judge, we would never. And he's like, look, I know you wouldn't, but if you did, would you view that as discretionary? And they said yes. I mean, and basically the takeaway is they could decide in their discretion, we don't like you. No real factors to it. But, they're shifting the burden. And instead of being this individualized review, we're kind of seeing these policy-based negative discretion. Instead of saying, we have looked at your application and your background, and we are going to view this as negative discretion. It's just saying, you got to flag an NCIC. You're somebody from this country. We view this as bad. Tell us why it's good.
Yeah, no looking at what the issue is in NCIC. It's just the fact that you've been fingerprinted. I mean,
or who the individual is. I mean, I have an individual who has a national interest waiver, and he's subject to some of these discretionary policies that they have.
And yes, even if they have discretion, there's such a thing as abuse of discretion. Where is the line?
Yeah, and that's, what I think Judge Willett was trying to get at. We know certain things are discretionary, but discretion has to be lawfully applied. There's left and right limits of discretion. You can't just sit there and say, in my opinion, like, we're going to say Catholics, or we're not going to do adjustment of status for Catholics.
All right, so that is kind of the travel ban issue with discretion. What about this criminal issues with negative discretion?
Yeah, this is what we're seeing. We've seen a good part of last year. We had the student visa stuff, and then like I feel like that summer, last summer is when we started seeing this pop up with criminal issues. And we saw somebody, they normal benefit, they get a biometrics appointment, and like my first thought is like, why? Like, are they going to get detained? Like, what's going on? Thankfully, nobody that we've worked with has been detained going for a benefit when it's an old criminal issue. There might be other situations. And then they get an RFE saying you were arrested, cited, what charged with something. Maybe they recognize it in the notice, or maybe they don't. Maybe they just say, you have a criminal record. What's up? And asking for all of it and say, we're going to deny this benefit as a matter of discretion. Provide us all the court records, as well as, from our end, provide positive factors.
But what if the case was dismissed? I mean, what happened to innocent until proven guilty? If the case is dismissed, they've not been proven guilty.
I know. I think it's, pretty harsh. And that's part of the analysis I think we do at our office. Like, there is the factors for admissibility and removability and how that interplays. From immigration, it's an arrest, is an arrest, and it doesn't matter. But we can go through a more detailed analysis of this, what actually happened through the case. Doesn't make the individual inadmissible on its face or removable on its face. That doesn't mean they can't exercise discretion.
All right. So, what kind of documents does someone need to gather if they get one of these requests for evidence or notice of intent to deny?
Yeah, and this is, where I tell people talk to their criminal law attorney, because a lot of them have gone and gotten expungement orders, and so they can't get it from the court, but try to get it from the court first, right? If you can get on, or your records, whatever the certified court disposition documents, when the charge was dismissed, or maybe you pled down, or maybe there was a guilty plea on a reckless driving, conviction on a reckless driving, like get the document that says, here was what happened, okay? Get that, get the charging document and the police report. Make sure it helps. Sometimes police don't have all the facts. They get some and put it in the police report. Look at that, and build a timeline with what happened and when, and walk through it. And then, explain why these carry what weight they carry. I mean, I do think, expungement orders don't really matter for purposes of immigration, but I still use them as a discretionary factor, right? Because yes, they were arrested, but this was such a non-issue that not only was it dismissed, but the court saw fit to expunge it. So it doesn't exist really from the public record. And I think that is important. Like I said, even though you still have to disclose the arrest, even though they can still ask you about the arrest, I think there's value to an expungement agreement.
Now, sometimes people that have some sort of law enforcement interaction or court case or something like that, they'll have a lot of documents. There's going to be all kinds of different motions filed. You've got the arrest report, the criminal complaint, then the final disposition and all of that. Do you submit all of those?
I don't. I mean, I kind of go through, and I think there's things we should submit and things we don't. Like, I don't need every discovery, order or motions and all that. But I'm looking for like the charging documents. Because from my end, like what happened, I do want to review the police records. I do want to review witness statements, because we can maybe put something together. Maybe there was a witness that said Emily didn't do anything. I don't know why she was detained. Great. Let's use that. But I do, you got to go through, but I don't want to over give either. Maybe Emily and I are fighting. I said, Emily is the worst person ever and did da 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 da. And who knows if I'm telling the truth? It's a witness statement.
Yeah. So it's definitely important to provide all of those to the attorney that's preparing the case, but it doesn't mean they have to include all of those in the response.
What about positive factors, Emily? So we got the court records, but we've talked about positive discretion and why they should exercise discretion. What are you looking for?
Yeah, this is where you can be creative. There's no right or wrong to it. So you just make an argument. So I made an argument that the fact that you went to the biometrics appointment is a positive discretion.
You're not hiding anything.
Exactly. The fact that you have gone for visa stamping 8 times already and been successfully given a visa. The fact that you've been given visas to go to other countries. The fact that you've constantly maintained your status. Here are all the I-797 approvals showing that I've never had an immigration issue before. The fact that this is the only issue that you've ever had, only law enforcement interaction. The fact that you filed your taxes. I've submitted tax returns for the last 3 years. Your education background. You might have a master's degree. You might be doing a really important job. So your experience history, like what you've done for your employers, the fact that you have a really strong job offer that you're waiting for, that you need this application to be approved to take up that job.
I've done character statements, if they've got employers or colleagues that are like, yeah, you're a good person, they come to work, all that. It's selling yourself.
Yeah. Family ties. If you have a U.S. citizen kid, milk that
Yeah.
for all you can.
Yeah, I would.
Community ties, volunteerism. Like if you constantly, volunteer your time for a charity or give money to a charity, church ties. Any of
Then why are you a good person?
Yeah.
And I hate to boil it down to that, but when I talk to clients, what can you provide me that shows you're a good person? And that's irritating, I think, to some people to what do you mean I am a good person? I have this one issue.
Yeah, you have to give USCIS a reason to say yes, basically. But there are some things that some people think might work that I'm a little skeptical of and I don't include. So one of my recent cases, the individual had a medical issue. And while this whole arrest issue was going on, they ended up having to have an organ transplant. And so they had documentation of that as well. And they're like, can you include that? And I'm like, I'm not sure how it shows that you're a good person, for one. And number two, I don't want USCIS to think you're going to become a public charge because you have this medical.
And they're saying they will.
Yeah.
Right.
So I don't want to open up another can of worms unnecessarily.
Let's move on, Emily. We talked about 2 issues. This 212F issue, what are we seeing?
Yeah. So, there is this memo that USCIS put out that said basically if there is a country-specific issue that has caused a travel ban, a presidential proclamation, an executive order, whatever you want to call it, we are going to treat that as a negative discretionary factor because we think you have somehow circumvented the travel ban. Now, it doesn't matter that maybe you were already here before the travel ban was implemented, so how could you circumvent it?
Right.
Or even if you came after, there, as you mentioned before, there are tons of valid reasons why you would want to change status or extend your stay versus going out of the U.S. and then subjecting yourself to this travel ban.
Yeah, and this, I think is extremely questionable from a legal standpoint. I mean, using 212F, which is an entry ban as a adjudicative factor, is absurd. I think on its face, I think it gets into some country of origin discrimination type question, from a constitutional perspective. But the practical issue, look, I can pontificate all day long. How you go about responding is important on this. And I think what I would tell people is first make sure the proclamation applies. The first couple of these we saw were Chinese nationals from a 2020 proclamation that banned entry for FM and J for, I guess it was F and J, for higher education only, not undergraduate, Chinese nationals who have funding from the Chinese government. Okay, that's there. The way these notices of intent to deny are written are, you're a Chinese national, you have this proclamation, it applies to you. And they're not looking at the fact that the way it was written requires you to have funding from the People's Republic of China or be working with the government. And so first off, make sure it applies to you. So that would be, I have one that I'm going to be working on next week that my first argument is it doesn't apply because he has no funding. The second Um, I would do that legal analysis that I think really is going to come from a lawyer explaining the difference between an entry ban and a change of status. Explain your compliance with laws, your history, and then again, those positive factors is how I would go about this. Like, no, it doesn't apply to me. Here's why this shouldn't be applicable, even if you thought it did apply. Here's why I'm here for a lawful reason, and here's all the nice things about me. That's how I'd kind of frame it.
Yeah, so I think we've seen cases where people have, the one supposed negative factor of there's a travel ban, and they submitted these 10 positive factors, and then they still get a denial.
Yeah.
Like, what do you do in those cases?
I am very intrigued about bringing one of those cases to court. And I think there's a little bit of nuance to it because there is some level of discretion to some of these, and it is going to be a lot more nuanced than typical. This denial is garbage, kind of thing, but I think it is something that needs to be challenged.
And in these denials, they don't go through each of the points you've made and say, okay, I see your point, but the travel ban outweighs this factor
Yeah.
because X, Y, and Z. Or you've given these 10 positive equities, but they're very minor. They don't overcome this one very major. There's no analysis.
No,
And so I think that kind of goes to show they're not using their discretion.
no, exactly, right. And I think this is the arguments I want to make. One is, we aren't doing individualized decision making when you're doing this across the board. And then number two, I mean, I think there's an issue when you have a policy, like what discretion is being applied. Like if you set a policy as our managing partner and you say, this is how we are going to do things, and do I have discretion to say no? Like I'm not, like that's not going to happen. And so I don't know how much actual discretion there is on some of these.
All right. So I think the other worry is as of now, we've seen this pretty much based on two presidential proclamations, the one regarding Chinese graduate students with funding, and the other, the 19, now 35, now 70 country travel ban. What if are there other travel bans that this could expand to?
Yeah, I think the H-1B $100,000 proclamation is couched as a 212F entry ban, right? Certain H-1Bs are banned unless they've paid this $100,000. Okay. We haven't seen it. The memo is country specific, says, hey, you can take country specific, bans as a negative discretion. And so we have these proclamations that say these countries' national security risk. Whereas truly, the $100,000 proclamation was more of an economic, not national security type thing. But if that change, could they change how they're going to view that?
Yeah, I mean, if what allows them to do this for these other two travel bans that are country specific is a memo that says we can do this for country specific travel bans, what's stopping them from just issuing a new memo that we can use it for any travel ban? And anyone who's subject to a travel ban, if they would have been outside the US, is therefore trying to circumvent that travel ban by filing this application. That's a negative factor.
Yeah,
I'm very concerned about that for this. What's stopping them from saying, like, if you were outside the US, you would have to pay $100,000 to get this or qualify for an exemption. Well, show to us that you've got these positive factors to qualify for an exemption to overcome this discretionary analysis.
Anyway.
Yeah.
So let's kind of my new theme for 2026, Emily, is I want to pull out some silver linings. Okay, I want to try to stay a little
Good
positive.
luck.
It's my goal. Okay, we'll see. The one positive, with the arrest, notices of intent to deny. This freaks everybody out. They get it. They're like, "Oh my God!" It says notice of intent to deny. What's going to happen? I know of one that was denied on an arrest record. They like knock on wood, right? Like based off of what we have a pretty good network on cases that we have consulted with, cases Rahul has talked to on his live, our weekly live. um, our network, like I'm only aware of about five. They, especially when we're talking about dismissed crimes, are going fairly well. We have seen more on this country one, right? Like I know of at least one, and this is just starting. Um, so the positive, especially for the arrest ones, is I do think you can have success, but it's not going to be here's the documents. You can't treat the RFE that way. I think you actually need to think about getting a professional, even if you filed the benefit yourself, how to go about these. So try to stay positive on that.
Yeah, and definitely get help early. Like when you get a notice of intent to deny, sometimes they only give you 30 days to respond. So you do need to act quickly so that you can gather all of the necessary documents and have time to actually draft that individualized analysis, explain why this doesn't apply, explain why it's not legally sound, and then explain how you have these positive factors and how they outweigh the one negative factor.
Yeah, I don't think you could take a knee on it because it is going to take time. If it was some RFEs can be turned around really quickly, but this is one that I think is going to take time and digging to do.
All right. Well, thanks so much for joining us for our episode 2 of the new year of Visa Vibes. We'll be back again in a week with more updates on what's going on.